Hi, and welcome to today's webinar, which is on changes to Queensland's guardianship laws and forms. My name's Carly Hanson, and I'm one of the Sector Sustainability Coordinators here at Community Legal Centres Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, they are the Turrbal and the Yagara people. I'd like to pay my respect to elders past, present and future, and acknowledge the important role that Aboriginal and Torres Strait Islander people play in our society. As today's webinar is being viewed by people throughout Queensland, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a really warm welcome to any First Australians listening in today. So today we're really pleased to welcome Kim Chandler, the Director of Strategic Policy from the Department of Justice and Attorney General, who will be speaking to us today about some of the recent changes to the law underpinning Queensland's guardianship system, which came into effect in November 2020. So these include new forms for advanced health directives and enduring powers of attorney, as well as some explanatory guides and guidelines for the assessment of capacity. These changes implement a number of recommendations from the Queensland Law Reform Commission's report, including changes to the principles underpinning the legislation and enhanced safeguards to protect against and provide stronger remedies for responding to financial abuse. So Kim's going to chat to us about some of those changes, and it also just so happens that this week is Law Week, and the theme for Law Week from the 17th to the 23rd of May this year is Don't Wait Until It's Too Late. So it's absolutely perfect timing for us to be running this webinar. We couldn't have planned it better if we tried. So I'll hand over to Kim in just a moment and let her tell you a little bit more about herself. But firstly, just a bit of housekeeping. So today's webinar is being recorded. We'll have the recording available for you to download later today or tomorrow. The materials, which includes some PowerPoints, are uploaded into the GoToWebinar handout section and also have been emailed out to everyone who registered this morning. As per usual, we'll keep our questions to the end of the session just to have a good flow for today, but feel free to type them into the GoToWebinar control panel as you think of them, and we'll read them out for Kim at the end. So without further ado, I might now hand over to Kim. So just bear with me while I swap over the screen. She's here with me in the CLCQ office. So just a moment. Okay, great. Thanks, Kim.
Thanks, Carly. Hi, everyone. Good morning. I'm Kim Chandler. I too would like to acknowledge the traditional owners of the land of which I'm presenting today and pay my respects to elders past, present and emerging. So I'm Kim Chandler. I'm the director of one of the teams in Strategic Policy and Legal Services and DJAG. There's a number of teams, both civil law teams and criminal law teams in strategic policy, and I'm the director of one of the civil law teams. And we have responsibility for guardianship and administration, as well as other areas of civil law and public law, including law in relation to QCAT, right to information, information privacy, ombudsman, administrative review and judicial review, to name a few things. And we also led the guardianship reform, so the changes to the legislation and the development of the new forms and guides. So that's why I was invited to come along and chat to you about those this morning. And the presentation, they're huge reforms, so I can't go through all of them. We'd still be here quite a few hours on into this afternoon, which was pretty boring for all of us. But I'll just give you a presentation and go over some of the key reforms and the changes, the key changes to the forms and guides. So today we'll look at a bit of a background, quick background to the reforms. We'll look at the changes to the law first, and then we'll look at the changes to the forms, and I'll give you a bit of a rundown on the Queensland Capacity Assessment Guidelines, and finally give you some hints about where to find further information about the reforms. So the reforms were implemented by the Guardianship and Administration and Other Acts Amendment Act that commenced on 30th of November 2020, so November last year. And that Amendment Act amended the Guardianship and Administration Act, the Powers of Attorney Act, and the Public Guardian Act. And at the same time that those legislative amendments commenced in November, new forms for enduring powers of attorney, advanced health directives, explanatory guides to help you fill out those forms, and the Queensland Capacity Assessment Guidelines also commenced on that date. So the Amendment Act implemented many, but not all, of the recommendations from the Queensland Law Reform Commission's report, a review of guardianship laws, that was released in 2010. And for those of you who are familiar with that report, that QLRC didn't recommend a complete overhaul of Queensland's guardianship legislation at that time, but did make around 317 recommendations to amend a broad range of areas. And so the Amendment Act implements those recommendations that enhance, broadly, you would say they would enhance safeguards for adults with impaired capacity, provide a greater focus on human rights and contemporary practice for people with disability, and in many ways just really clarify the operation of Queensland's guardianship legislation. And the QLRC also recommended changes to the forms for EPAs and AHDs and to develop guidelines for the assessment of capacity. Now, we haven't implemented all those recommendations, so there's a number of recommendations in the QLRC report that remain unimplemented. Many of those actually are in relation to life-sustaining treatment and decision-making about life-sustaining treatment at the end of life. And as many of you would know, there was quite a big inquiry by a parliamentary committee into voluntary assisted dying, aged care and palliative care. Then the reports were tabled in 2020. There was one report on voluntary assisted dying and another report on aged care and palliative care. And in that parliamentary committee report, the committee recommended that government implement the remaining QLRC recommendations in relation to life-sustaining treatment. And government has accepted that recommendation in principle, but those you won't see those recommendations as part of this tranche of reforms. Not yet. They're still government is still considering how to implement them. So some of the key changes to the law that were implemented by the reforms in 2020 that came out of the QLRC recommendations included changes to the general principles and the healthcare principles that underpin the legislation, changes about how to, or clarification about how to apply the presumption of capacity, clarifying the different tests of capacity for making an enduring document, so that's an advanced health directive or an enduring power of attorney, small changes to the eligibility requirements for attorneys, a limit to the number of joint attorneys, some clarification around conflict transactions, and some broader remedies to be made available when an attorney, administrator or guardian has failed to comply with their duties or their obligations under guardianship legislation. And some of the other changes to the law that were implemented as part of those 2020 amendments that were not QLRC recommendations include recognising the role that support plays in determining capacity, a requirement for QCAT and others to take into account the views, wishes and preferences of an adult, the power for QCAT to order an attorney, administrator or guardian, or importantly a former appointee to compensate a principal or a principal's estate, providing a legislative exception to redemption in certain circumstances, and providing QCAT with a new jurisdiction to appoint an administrator for a missing person. So I'll just run through those from the beginning. So first of all, changes to the general principles and the healthcare principles. So these principles provide guidance for people and entities, including QCAT, exercising powers and functions under Queensland's guardianship legislation, with the aim of ensuring the rights and interests of adults with impaired capacity are properly considered. So those principles have been relocated from the schedules to the Guardianship Act and the Powers of Attorney Act, right up front to the beginning of those acts. And they've been redrafted to, I guess, more closely align with the relevant articles of the United Nations Convention on the Rights of Persons with Disabilities, to provide a more logical structure, to remove duplicating matters dealt with by both principles, and to provide further guidance about the application of how you apply the general principles when you're delivering healthcare. So I won't run through them all, but there's you'll see them in the legislation, but there's also a fact sheet that's available on our website. It's pretty easy to find if you just search guardianship reforms Queensland, and it will come up with some information about the reforms and links to all the new forms and guides, including our new fact sheets. And one of the new fact sheets is an outline or a summary of the general principles and the healthcare principles. So the general principles have been refined to reflect more contemporary language. For example, language such as safeguards is used rather than protection, and it's the adult's rights, interests and opportunities that are promoted rather than the older term best interests. New Principle 10 also provides a more structured approach to decision making, which is more aligned with convention, to emphasise supported as opposed to substitute decision making. So, for example, New Principle 10 really does emphasise recognising and supporting an adult's right to make their own decision, and recognising and taking into account any views, wishes and preferences expressed or demonstrated by the adult before resorting to substitute decision making. And finally, the principles have been redrafted to refer more directly to the underlying philosophy of the Convention. So there's new direct references to non-discrimination and the respect for difference, including the acceptance of persons with impaired capacity as part of human diversity. So that's the new principles, and I think they give a good, they underlie some of the new philosophy. They brought Queensland's guardianship legislation, made it a little bit more contemporary and brought it, I guess, out of a more protective sort of paternalistic approach into a more modern sort of contemporary rights supporting approach, which is important. And it's important that those principles are front and centre to that legislation. So in addition, and I guess supporting, running through the principles and some of the other changes to the legislation, a number of amendments have been made to recognise and acknowledge the importance of support when you're determining a person's capacity. So Section 5 of the Guardianship Act was amended to provide that the capacity of an adult may differ not just because of the nature and complexity of the decision that they're going to be made, but also the support available to the adult from their support network. And as I said previously, Principle 10 emphasises the importance of recognising and supporting an adult's right to make their own decision. And new Principle 8 recognises that an adult is not to be treated as unable to make a decision about a matter until all practical steps have been taken to provide that adult with the necessary support and information to make and also communicate that decision. So I think that's a quite important paradigm shift for Queensland's guardianship legislation that was probably quite well overdue. Now, the presumption of capacity. So you'd all know that under general law and under Queensland's guardianship legislation, all adults are presumed to have decision-making capacity, and that's reflected in the general principles as well. The QLRC, however, considered that the application of the presumption of capacity required a bit of clarification in certain circumstances. So a common law, of course, an adult's presumed to have capacity, but that, as we know, is a rebuttable presumption. So in some cases where the presumption has been rebutted, where, for example, QCAT has found that an adult doesn't have capacity and for a matter and has appointed a guardian or administrator, both the Supreme Court in the case of Bucknell, that you'll see there on your screen, and Guardianship and Administration Tribunal, and the QLRC considered it didn't make sense to ask guardians and administrators to continue to apply that presumption once they were appointed. So if guardians and administrators couldn't rely on QCAT's finding that an adult didn't have capacity for that matter, then it would be very difficult for them to carry out their duties on a day-to-day basis. So Section 11 of the Guardianship Act, a new Section 111A of the Powers of Attorney Act clarify that presumption by emphasising first that QCAT and the Supreme Court have to presume that an adult has capacity for a matter every time until the contrary is proven, but also providing certainties to substitute decision makers by not requiring the guardian or administrator to apply the presumption after QCAT or the court has made a finding that the adult doesn't have capacity for a matter and they have been appointed as guardian or administrator. So now this doesn't remove the requirement for QCAT to apply the presumption when making a decision about the adult's capacity, or indeed when they're considering a review of the appointment of that guardian or administrator. All it does really is provide some certainty for substitute decision makers and third parties who need to rely on their decisions once they've been appointed. Continuing on with the theme of capacity, you may know that there's two tests of capacity under Queensland's guardianship legislation. First, there's the general test of capacity, and you'll find that in the schedules to both the Guardianship Act and the Powers of Attorney Act. And this is the default test that we use, and no significant change has been made by the reforms to that definition, save the insertion of a note to emphasise that all reasonable means should be used to facilitate communication before a person is treated as unable to communicate. So just to sum up, the general test of capacity means that the person is capable of understanding the nature and effect of decisions about a matter, freely and voluntarily making decisions about a matter, and communicating a decision about that matter. So all three limbs have to be satisfied to have capacity. But there's also a specific test for capacity for executing an enduring document. So that's an advanced health directive, an enduring power of attorney, and that's set out in sections 41 and 42 of the Powers of Attorney Act. And the QLRC did recommend some clarifying amendments. First, to clarify that the general test doesn't apply when you're considering the capacity of an adult to execute an enduring document. And second, to clarify that capacity test needed to make an enduring document. So the reforms clarify that to make an enduring document, the adult both generally, I won't go through the full test, which you'll see in the Powers of Attorney Act, and you'll also see in the new capacity assessment guidelines in section 6, which I'll talk more about later. It provides you with details about what the test of capacity is for making an enduring document, but the broad sort of high-level summary is that the adult must be capable of understanding the nature and effect of the document they're making, and they must be capable of making that document freely and voluntarily. But more information about the test is available in the legislation and also in the guidelines, and it really is specific to the type of document the adult's making and probably the complexity of their arrangements and the types of powers that they're giving under that document. There were some really minor changes to the eligibility for attorneys. So there's eligibility requirements in section 29 of the Powers of Attorney Act to be appointed as an attorney under an enduring power of attorney or an advanced health directive. There's some minor additions. So to be an attorney under an enduring power of attorney, the amendments clarified you have to have capacity for that matter, and also found that you must not have been you can't be a paid carer to be an attorney, and also you can't have been a paid carer in the previous 3 years before your appointment. And a paid carer is not someone who's receiving the carer's pension or a benefit, but someone who's paid a fee or a wage to provide care. And for an attorney under an advanced health directive, in addition to the usual criteria, again, the amendments clarify you have to have capacity for health matters, and you can't have been a service provider for a residential service where the principal resides. And in this context, a service provider has a very specific meaning. It's a residential service under the Residential Services Accreditation Act, which we sometimes call a boarding house. There's also been changes to the number of joint attorneys that you can appoint. So as you would know, if you're appointing more than one attorney in an enduring power of attorney, you can choose how your attorneys make decisions. And if you don't specify how they make decisions, then they're all required to make decisions jointly, which means all your attorneys have to agree on every decision to be made. Otherwise, you can choose that they make decisions severally. Any one of your attorneys can make the decision without being necessary to agree with the other attorney by a majority or other. And that also enables you to appoint successive and alternative attorneys when some attorneys aren't available. But the amendments provide that if you are appointing joint attorneys, there can only be a maximum of 4. And the QLRC considered that more than 4 joint attorneys can make decision-making rather cumbersome and maybe not be of benefit to the principal. So we've put that limit in place. Okay, so that's attorneys and eligibility. Now we're moving on to some trickier areas, I guess, around conflict transactions. So you'd probably all know that a conflict transaction is a transaction in which there may be a conflict or results in a conflict between the duty of an attorney or an administrator towards the principal or the adult and the attorney's own interests or the interests of a relation or a business partner. So, for example, an example of a conflict transaction would be where an attorney may want to buy the principal's car. So this type of transaction is a conflict transaction because the attorney's duty to the principal to ensure that the principal obtains the highest possible price for their car is in conflict with the attorney's own personal interest in purchasing that car. So amendments have been made to Section 37 of the Guardianship Act and Section 73 of the Powers of Attorney Act, first of all to provide some more examples of what a conflict transaction is, because I think often there was a lot of confusion which wasn't helped by the legislation and wasn't helped by some of the examples, in fact, that were in our own forms about what conflict transactions were. So, for example, a conflict transaction happens if an attorney loans the principal's money to a close friend of the attorney, or if an attorney rents the principal's residential property to a relative of the attorney. A conflict transaction also happens when a principal's money is used to pay the personal expenses of an attorney, for example, their travel expenses. And a conflict transaction happens if an attorney for a financial matter buys the principal's house. So the overall purpose of the amendments to the conflict transactions provisions is to emphasise that administrators and attorneys should seek prospective authorisation from QCAT or the court before entering into a conflict transaction. So you can enter into a conflict transaction if you're an administrator or an attorney, but you have to get authorisation first in advance. And that is either from the principal themselves in an enduring power of attorney or from QCAT or the court. But the amendments also emphasise that until that you can get that authorisation both prospectively and retrospectively. So you can get it before you undertake the conflict transaction, or you can get it after you undertake the conflict transaction. But importantly, if you get it retrospectively, until that conflict transaction is authorised, you've acted, if you're an attorney, you've acted contrary to your duties and obligations. So I guess going back to that example of the attorney wanting to buy the principal's car, this is a conflict transaction. The principal may decide to authorise the attorney to do that first up in their enduring power of attorney. If that hasn't happened, the attorney might want to go to QCAT to seek authorisation to engage in that conflict transaction. If they don't do that and they do it anyway and buy the principal's car, then they've acted in contravention to their duties and obligations by engaging in an unauthorised conflict transaction. You could then go as the attorney to QCAT to seek retrospective authorisation of that conflict transaction, and QCAT may decide or may not decide to give you authorisation, and it may decide to give you authorisation taking into account factors such as whether you paid market price, the price you paid for the car, that kind of thing. And if it doesn't decide to give you authorisation, then you're in breach, and there may be a whole other types of remedies that might be available to that adult or their estate. So hopefully the changes, it's all very complex, conflict transactions, what they are, and hopefully the changes, including the clearer examples, spell out more clearly what conflict transactions are and how they work under Queensland's guardianship legislation. There's also been some changes to the law around remedies. So following on from conflict transactions, which unless authorised is a breach of your duty under guardianship legislation, attorneys, administrators, guardians have a whole lot of obligations and duties that they have to comply with. And when they breach them, there's a whole lot of remedies under Queensland's guardianship legislation. One of the areas that was unclear under Queensland's guardianship legislation was the ability for QCAT or the court to order, QCAT actually, not the court, to order compensation. So under the Powers of Attorney Act, the Supreme Court or QCAT can order an attorney. Under the Powers of Attorney Act and the Guardianship Act, either the Supreme Court or QCAT can order an attorney or administrator to pay the principal compensation for a loss caused by their failure to comply with their duties and obligations. But in Queensland, case law had developed so that QCAT considered that it didn't have that power when an enduring power of attorney had been revoked. So if the principal had died or it had been revoked for some other reason. So QCAT considered it didn't have the power to order compensation where in relation to the actions of a former attorney or to the principal's estate where the principal had since died. And this was reflected in the cases of LPJ in 2011 and Public Trustee of Queensland and BN and others also in 2011. So importantly, the reforms clarify that QCAT can order both a current and a former attorney, administrator or guardian to pay compensation for a loss to the adult or the adult's estate caused by their failure to comply with their duties. So that's quite an important clarification, because sometimes not only may the attorney die and not only may the principal die, so the attorney is of course no longer an attorney because the power of attorney has been revoked, but also the power of attorney may be revoked for other reasons because the attorney has been breaching their duties and obligations. So it's really important that the QCAT has that power to order compensation even if the enduring power of attorney has ended. We've also added some additional remedies that the Supreme Court and QCAT have an additional power to order that an attorney, guardian or administrator or former appointee can account for any profits accrued as a result of their failure to comply with their duties. So I guess in summary, the reforms have enhanced the availability of remedies and clarified their application, particularly in that area that I just described in relation to former attorneys. Okay, another really big change to the law that wasn't one of the QLRC recommendations was an introduction of a statutory exception to redemption. Now, this is quite a complex area, but the high-level summary is that redemption occurs when the gift of a specific item of property in a will fails because, prior to the testator's death, the specific item is considered to no longer form part of the testator's estate, either because that gift is sold or it changes its form in a manner that no longer can be described as it could be originally in the will. So to give you a common example, a person may leave their house as a specific gift, a testamentary gift under a will, but then that house, after the person loses capacity, that house has to be sold upon their entry into aged care, which is a very common scenario these days. So upon the person's death, the gift is redeemed because it no longer exists. It doesn't form part of the testator's estate. And even if that's the case, even if the proceeds of the sale can be traced or is still there in the estate. So when the gift is redeemed, the proceeds of the sale of that house just pass into the residue of the estate and are distributed amongst the residuary beneficiaries, which means that beneficiary that was meant to get the house misses out. So common law, this redemption rule is really strictly applied. However, there is a known exception where the sale of the property, the gift, happens through a fraudulent or a tortious act, but it was unclear in Queensland about whether an exception to redemption also existed when an attorney or an administrator dealt with property that was a gift under a will after the person had lost capacity. So the reforms introduced this statutory exemption to redemption to clarify the common law. But importantly, it's in the guardianship legislation, so it only applies in circumstances when an attorney or administrator sells or disposes of property of a principal, and it's a statutory exemption which is in the Guardianship Act and in the Powers of Attorney Act. So the new provisions create a statutory exemption to redemption where an attorney under an enduring power of attorney or an administrator sells or disposes of property which is the subject of a specific gift in a will. So what it will mean is that the beneficiary who would have succeeded to that deemed asset will have the same interest in any surplus money or traceable money or other property arising out of the disposition of that property. And it's an automatic statutory exception, so you don't need to apply to the court for that to occur. It just happens automatically. However, I won't go through them all now because it's very tedious, but there are a whole lot of other provisions that you'll see in the Guardianship Act and the Powers of Attorney Act, which allow you to apply to the court to adjust how the statutory exception works. And for example, you may want to do that if there are very small proceeds left from the sale of the house, for example, and it would mean that the person who was meant to be getting the house under the will now get a very small amount or vice versa. So you can apply to the court to adjust their entitlements. So that's a statutory exception to redemption. But it brings us into line with a number of other states. So we're not out there on our own doing that amendment. Now, there's all the further changes to the law. Again, not a QLRC recommendation, was to give QCAT the power to appoint an administrator for a missing person. So generally at law, a person's not to be presumed dead until they've been missing and there's no evidence of them being alive for 7 years. So prior to that 7 years, the presumption is that a person is alive, and rebutting that presumption is very hard. It can be very difficult and an onerous task for people. And in the meantime, there might be very pressing needs to deal with their property. So as in the ACT, New South Wales and Victoria, Queensland now has a QCAT is able to expressly or specifically appoint an administrator where a person is missing. And of course, that if you look at the provisions in the Act, it will give you more detail about the criteria that has to be satisfied and when that appointment ends. Alrighty, so that was all the changes to the law that I wanted to go over today. There's many more. So if you go to the explanatory notes for the Guardianship and Administration, another Acts Amendment Act that commenced on November 2020, or go to our website. If you just search up changes to guardianship laws, you'll have more information and links to further information about all those changes to the law. Now, at the same time that the changes to the law commenced, we also released new forms for enduring powers of attorney and for advanced health directives, and also new explanatory guides to help you fill out those forms. So first of all, enduring powers of attorney. I've just got the pictures of them there on the screen, but again, they're readily available on the internet. And as per before, there's still a short form and a long form. So you use the short form to appoint attorneys for personal matters only or financial matters only, or if you want to appoint the same attorneys for personal matters and financial matters. And you use the long form to appoint different attorneys for different types of matters. So they're still there, but there is the addition of the explanatory guide for how to fill out an enduring power of attorney. I'll just go over some of the new sections. They look very different, but the changes to the law haven't been dramatic. So there's not a great difference in substance, except for a few of the things that I'll talk to you about today. So first of all, there's a bit of an expanded section of what we call a values section at the beginning of the enduring power of attorney form. It reflects the new general principles that attorneys and the attorney's obligation to seek the principal's views, wishes and preferences when they're carrying out their duties. But it's not, of course, the same as giving instructions to the attorney, and that's spelt out in the form and in the explanatory guide. And it's also part of what we call a conversational or a values approach to advanced planning, so that the person is encouraged, the principal filling out the form is encouraged first to think about what's important to them, think about their values, think about what they want in the future before they start appointing attorneys and setting down terms and instructions in that enduring power of attorney. So they're prompted to think about what matters to them most and what's important for their quality of life, both now and into the future. Now, another new big section in both enduring power of attorney forms, the short and the long form, is that while there's always been a section, of course, for principals to set out the terms on which the attorney exercises their power and to provide instructions about how they have to exercise that power, there's now a new section allowing the principal to give specific instructions about what we call notifications. So this is responding to a recommendation of the QLRC and also to stakeholder consultation. So the QLRC saw value in a scheme where an attorney was required to notify another person when they commenced exercising their powers under an enduring power of attorney or exercised certain powers. The QLRC didn't think it was necessary, however, to embed that in legislation and make it mandatory, but to give an option in the form for principals to do that if they wanted to. So really what it is, I guess, is giving the opportunity for a further pair of eyes over the exercise of the attorney's powers. So for personal matters, the principal can nominate a person to receive notifications and specify that they want that person to be notified when the attorney begins exercising powers, and also they can specify other types of information that should be provided to that nominated person. For financial matters, it's the same thing. The attorney can specify the persons they want to receive notifications, and then specify there's quite a long list there of certain things like summaries of income, expenditure and accounts, records and accounts of all assets, and also specify the time periods on which they should be provided. Now, this, of course, imposes a much greater obligation on attorneys who are exercising powers like this under an enduring power of attorney and have these extra obligations. So the explanatory guide really emphasises that the principal discuss this with the attorney they intend on appointing, so that they're clear that what they will need to do once they begin exercising their powers. So there's also new forms for advanced health directives and also an explanatory guide for filling out the advanced health directive. You can see the pictures of them on the screen, and again, they're readily available on the internet. And like the enduring power of attorney, there hasn't been significant changes because, again, the changes to the law haven't been that significant to substantively change the forms, but they look very different. And there's a couple of key differences that I'll just go through today. The first one is, again, what we call a values section at the beginning of the Advanced Health Directive. And there was strong feedback from stakeholders that that should be included again. So it's part of that sort of conversational approach to advanced planning, so people can be prompted to think about what's important to them and what they want before they start giving binding directions about their healthcare for the future. In the case of the Advanced Health Directive, though, as you can see, there's a lot more prompts in relation to people thinking about what they want for their future, things about what is important to them, what living a good life means, what worries them about the future, what would they be concerned about in the future as they're nearing death, their cultural, religious, spiritual beliefs, and other rituals and beliefs that they want considered in their healthcare. If they were nearing death, what would comfort them? As well as the people they would prefer to be involved in discussions about their healthcare and the people they would prefer not be involved in discussions about their healthcare. So hopefully the way it goes is that a person sits down, has the conversations with the people that are important to them, including their healthcare provider, and thinks about these things. And they don't need to fill in this section. It's not compulsory at all, and they're not instructions, but even thinking about them might help with filling out the rest of the form. The other big change is the change to life-sustaining treatment. This was a really difficult change to make in the form because lots of people wanted lots of different things, and giving directions about life-sustaining treatment at the end of your life is really difficult. But the main feedback we got was that from stakeholders is that they didn't want a one-size-fits-all circumstance. So they wanted principals to have the opportunity to refuse all life-sustaining treatment, consent to all life-sustaining treatment, or in fact give different directions depending on the life-sustaining treatment, depending on the conditions under which it's provided. So that was quite difficult to carry out, and I think we've done our best. So you now have 4 options. You can consent to all treatments. You can refuse all treatments. It was acknowledged that some people may not be able to decide, and they want to trust their attorneys to make those decisions. And finally, option 4 gives you the option, a bit like the old form, that tick box approach, to give different instructions depending on the life-sustaining treatment that you're talking about, as well as an option for adding other types of life-sustaining treatment. So you can choose to consent to it. So for CPR, for example, you can choose to consent to the treatment in all circumstances, refuse it in all circumstances, and consent to it in specific circumstances. And then that's the same for all life-sustaining treatment. And as you would know, you probably already know at the moment under Queensland law, there's very specific circumstances when these directions are binding. So you have to have lost capacity. You have to be unlikely to regain capacity to make your own decision about life-sustaining treatment. And basically you have to be so unwell that you'll either likely to die in the next 12 months, or there's no reasonable prospect that you will recover to the extent that you can live without that life-sustaining treatment or be in something like a persistent vegetative state. So this only applies in very, very distinct or specific circumstances. Okay, so finally, come to the guidelines for the assessment of capacity. Yes, these are very new. We haven't had these before. The Queensland Law Reform Commission looked at the test of capacity, how it was applied, or the common law around applying the test of capacity relevant for Queensland's guardianship legislation, and thought one option was to provide all that guidance in legislation, but erred against that and decided it was better to provide guidance in guidelines that were made under the legislation. So this is what the Queensland Capacity Assessment Guidelines do. And they were developed in consultation with a reference group, with health, community, legal, and academic stakeholders. It's important to note, though, that these are not the guidelines for assessing capacity under all circumstances. They're only relevant to Queensland's guardianship legislation, so for assessing matters under that legislation, so for assessing personal and health matters and financial matters and power to make an enduring document. As we discussed earlier, there's those two tests of capacity for that. If you can see that on your screen, that's the title page from the Capacity Assessment Guidelines. Gives you some information about capacity. There are some principles as recommended by the QLRC about underpinning how to undertake a capacity assessment. There's information about the general test of capacity. There's a checklist, a step-by-step guide to conducting a capacity assessment. There's practical tips and hints, case examples and checklists to help. Section 6 is specific to making an enduring document, and then there's some information, some hints on where to go for further information. And while it's, there's many people who may need to assess capacity under Queensland's guardianship legislation. Health providers, for example, if they want to be sure if a person can make their own decision. Social workers, if they're considering applying for a guardian or applying to QCAT for a guardian or administrator. But importantly, as you know, it's only QCAT or the Supreme Court who can make a binding decision about capacity. So these capacity assessment guidelines are important because it's important that people go through a reasoned and logical process to testing capacity because that presumption is there, it's rebuttable, and if you're appearing before QCAT or the Supreme Court, you need to show the steps you've gone through to illustrate your conclusion or your opinion as to why or why not someone has capacity. So that was a lot of talking by me, I'm sorry, but I'm happy to answer any questions, and there's some links there for more information.
That's great. Thank you so much, Kim. Lots of information, but, lots of really helpful stuff, I think, for our sector. So we've had some questions come through, which is really great. So I'll just sort of go through those from the top, I reckon. Okay. So just bear with me a tick. Okay. All right, so these questions are a little dense, so I'm just going to read them out, and Kim will do her best to respond to those, noting that she can't give any legal advice as per usual for our webinar sessions. So the first one's from Bernie. So who's got a client with a guardianship order. They're instructed by the public guardian on his behalf to manage his immigration matters. Last month, they sent a QCAT order saying the guardianship had been revoked with no explanation. Could that be because of these changes? How can they find out more about what led to the order? And just a bit more context around the client having an acquired brain injury, unable to speak, write, or remember anything. So it's really difficult to see how he might have been able to instruct them directly. So I'm not sure if you're able to really respond to that one, Kim, but it's a bit
It sounds very tricky,
Yeah.
yes, and it's probably specific to that person's situation. Off the top of my head, I can't see how the reforms would have led to that outcome. And all I can suggest is that you contact the public guardian, I guess, to get some more information, or indeed, if you believe that person doesn't have capacity, that you may want to consider making another application to QCAT. But again, it's obviously there's a lot of the devil's in the detail with that case, but I can't off the top of my head see how the amendments would have led to that change.
Okay, thanks, Kim. So Alex has asked whether the remedies have been tested yet in QCAT or in the Supreme Court.
I don't know that to my knowledge. Sorry, Alex.
No worries. Alex, maybe you can check that one out yourself.
Yep.
Okay, so Drew has asked or mentioned that these amendments are placing a greater workload on QCAT. As it stands, there are, already huge delays in QCAT. So is there anything that you know of that's being done to alleviate that situation?
Oh, goodness. That is something probably you'd have to ask QCAT. I mean, the amendments were a long time coming, I've got to say. And as anyone who's been following this law would know, the QLSE made its report in 2010 and the guardianship amendments were in and out of Parliament as governments change. So QCAT has had a lot of warning, and I know they did do a lot of preparation for this jurisdiction. They had quite a bit of time, but I agree with you, QCAT is under a lot of stress, but I can't tell you specifically if anything's done to alleviate that in relation to guardianship matters.
All right. Drew's also asked whether there's a definition of a missing person, which you mentioned.
Yes, there is. I'm just seeing if I can find it.
Kim's actually brought a copy of the Act, so she's just looking through the pages.
So it's in Section 12A of the Guardianship Act, and the tribunal has to be satisfied that it's not known, excuse me, if the person is alive. Sorry about that. I just had to have a sip of water. So it must be not known if the adult is alive, if all reasonable efforts have been made to locate the adult, and for at least 90 days the adult has not contacted their last known home or address or any friend or associate. So I guess QCAT could also, it can be informed however it wants to be, so it would also take missing persons reports, I think, from the police and other evidence. Yep.
Great, thank you. So Tracy is wondering, with regard to QCAT awarding compensation, for example, where an enduring power of attorney was gifted the principal's property by, that might be an attorney was gifted the principal's property by applying undue influence, would the pathway be a complaint to the OPG about the attorney's conduct, or is there a process to go straight to QCAT?
I think you certainly could make an application to QCAT, but the public guardian does have a statutory responsibility to protect the rights and interests of adults with impaired capacity, has an investigations unit, and I think that would be a great first step.
Okay, thanks for that question, Tracy. So Helen is wondering, in completing the notifications, is it appropriate for ongoing notifications to be provided to the principal?
Yes. So even if the principal, I guess you're alluding to, even if the principal has lost capacity, they might not have capacity for complex matters, but they might have capacity for other simple matters. And in accordance with the general principles, they also should be kept informed about the decision-making that's happening on their behalf. So, yes, I think it's quite appropriate for ongoing notifications to be provided to the principal.
And further to that, Helen has asked whether the principal is classified as a nominated person in the notification section.
Yes, they are.
Great.
As far as I can remember. Yep. Me, the principal, I think was one of the options. Yeah.
Yes. Okay, and a couple of questions from Val as well. So Val asks, is there any update on there being a registration system introduced for enduring powers of attorney and advanced health directives like they have in the UK and in other countries? And a second part to the question, but I'll go to that one after.
Well, as you know, the Australian Law Reform Commission did their report on elder abuse, and since that report, what used to be known as the Council of Attorneys General, so all the Attorneys Generals from around Australia, including the Commonwealth one, have been looking at those recommendations and have been looking at proposals for a national register. So that is part of the ongoing work of states and territories, although a final decision hasn't been made yet.
Great. And so I think you probably answered the second part of Val's question there about whether there will be an Australia-wide system rather than just states, similar to wills being recognised Australia-wide. So last question that's come through is from Erica, and she's asked whether you know of any other cases in QCAT where they've authorised a conflict transaction.
Oh, I can't tell you any off the top of my head, but I'm sure there are some. But again, it would be about QCAT considering the particular factors in the case and whether it was, even if it was on the face of it, a conflict transaction, but wouldn't cause any detriment to the principal.
And Kim, there were a couple of comments that came through when people registered. So I'm not sure whether you're able to speak to these generally, but Louise has asked whether the changes alter or whether these changes alter the way capacity is determined for people turning 18 years of age with an intellectual impairment or not.
Yes, well, as you know, guardians and the guardianship framework really only applies to adults, so 18 years and over, and maybe you're alluding to, I guess, when parents are considering what to do about decision making for their adult child who's about to become an adult, becoming 17 or 18, there really isn't any changes that would specifically impact on that, except one of the many changes was that when QCAT is appointing a guardian for an adult child for parents, they're under an obligation about the duty to tell those adult parents about the ability to make successive appointments. So, in fact, if one of those parents were to pass away, that they could put in place other appointees. But I think the changes in the principles really emphasise that all other things should be tried first before making an appointment. And if the adult child is doing quite well with their parents and other members of their support work assisting them to make decisions, there may be no need for an appointment. And those decisions can continue to be made informally.
Great, thank you. And lastly, Erica mentioned that she wanted to learn about the new guidelines for assistance of capacity, which I think you covered, but also any changes that these amendments have on QCAT and how they impact QCAT.
Well, I guess the first up, the new changes to the principles, the healthcare principles will impact QCAT and because they're an entity that has to exercise powers under the legislation, so they'll be required to do that. As we went through, there's some new jurisdiction in relation to missing persons for QCAT. They have an obligation to make sure the person's views, wishes and obligations can be sought and taken into account if it's reasonably possible. We've clarified the remedies that they can provide QCAT along with the Supreme Court. They're probably the main ones that I can think about for QCAT.
Great. And Alison has helpfully noted that there's a public consultation paper on the National Register issued in April with comments by the 30th of June. So if you're interested in this area, do seek out that paper if you can. I'm sure that a quick Google will bring it up and you can potentially provide some feedback or comments. So I think that's everything today, and we're finishing exactly on time, which is fabulous. On behalf of everyone who's joined in today, thank you so much, Kim, for coming along and sharing some information about these changes to guardianship laws, capacity, and some of the forms. Thank you also for addressing all of those questions so well. So I'll just give a quick reminder for people to please provide feedback when this webinar closes. The survey will just pop up automatically, really quick few questions. That just helps us to make sure we're delivering what you need through this webinar program. I think that's everything from us. And yes, thank you again, Kim, and thanks for joining us today, everyone.
Thank you.